Chief Ms. Benson.
Good morning, how are
And
you?
you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000.
The officer jumps straight to probable cause, but here's the problem. The defense argues there was no actual traffic violation observed. Just a 911 call, describing a car. No wrong-way driving caught on camera. If the stop wasn't legally justified, everything after it, the breathalyzer, the arrest, could get thrown out. This case might collapse before it even starts.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On April 21st, 2025, in Harris County, Texas, a law enforcement officer was dispatched in reference to a wrong-way driver and initiated a traffic stop on the vehicle described by the 911 caller. The law enforcement officer made contact with the defendant, and the defendant handed the law enforcement officer an unopened alcoholic beverage. The law enforcement officer noticed the strong odor of an alcoholic beverage coming from the vehicle, and the defendant appeared unstable and fell against her car. The defendant stated she spilled a whole can of beer on herself earlier. The defendant's vehicle appeared to have fresh damage consistent with hitting a curb. Standardized field sobriety tests were conducted, where the officer observed 6 out of 6 clues in the HGN, 3 out of 8 on the walk and turn, and 0 out of 4 on the one-leg stand. An inventory search revealed 3 open and empty beer cans in the back seat floorboard and other unopened alcoholic beverages.
A .143 back is nearly double the legal limit, but here's what changes everything. The defense claims the initial stop was invalid. The 911 caller said wrong-way driver, but the officer never saw it happen. If the judge agrees this was a bad stop, all that damning evidence becomes useless. No stop means no case. That's how critical this legal technicality could be.
Defendant considered to breath and blew .143 and .145.
What did you say the stop was for?
The stop was for, there was a 911 call that stated there was a vehicle driving the wrong way and described the vehicle. The officer found the vehicle.
Driving the wrong way?
I'm not sure. Well, the officer found the vehicle was not driving the wrong way, but it matched the description given by the 911.
Right. Anyone can call and say anything. Did he view any kind of traffic infraction? I could literally call and say, hey, man, state's driving nuts. Go get him. Right? I mean,
There's
Yeah.
no other
Okay.
traffic infraction.
Benson, I'm going to find that there's no probable cause to go forward with your case. There's enough death and destruction on our streets now. Play it safe. The last thing you need is to end up in a 6x9 because if you get into an accident, maim, kill someone, especially with alcohol in the car. Do you understand? Play it safe. Don't make any boneheaded moves. Please. Thank you. Good morning.
I have an arraignment for Miss Rice.
You mind bringing her up?
I do believe PC has not been found or.
Okay. Good morning, Ms. Rice. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 22nd, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash call and found a vehicle inoperable due to a collision and blocking traffic. Law enforcement officers spoke to a wheel witness who stated he observed the defendant in the driver's seat of the vehicle with the engine on and advised the defendant to turn the vehicle off and exit the scene. The law enforcement officer made contact with the defendant who was sitting in the driver's seat of the vehicle and observed slurred speech, moderate odor of alcoholic beverage, and glossy eyes. The defendant admitted to consuming 1 alcoholic beverage. SFST standard field sobriety tests were conducted. A 6 out of 6 on the HGN was reported, a 7 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The defendant refused to provide a specimen. A blood warrant was obtained and executed.
If I may, Your Honor, what the officers completely failed to leave out of their report is that the car was registered to the other person that was present. The other person had the keys on them. The other person admitted to driving. At the time of the accident, I'm not sure why they switched seats. I don't know. I do know the wheel witness came after the accident had already occurred. They had been waiting on a tow. If the officer would have done any due diligence in his research or questioning, the other person they may have been intoxicated. I'm not sure. He didn't even follow up with them. they openly admitted, this is my car, I'm the one driving. The officer made no attempts to remedy that situation or even mention that in his report.
Have you had any of that?
Your Honor, I would just say that, I mean, based on what we have in the DIMS, we witness put the defendant in the driver's seat of the car.
After the car was already inoperable, he didn't see her, he didn't see the accident.
Your Honor, I would say for probable cause purposes, we have a wheel witness that says they saw the defendant behind the driver's seat.
Of an inoperable car.
And a law
I mean,
enforcement officer saw.
at the scene of the accident, right? I mean, if you have some kind of other evidence to show, I have to give them time also, you know?
Understand probable
I mean, this is just,
low burden, yes.
probable cause is a very low burden, right? So this doesn't mean that you're guilty. I mean, if that's in fact true, that's why we have trials, right? There's always two sides to the story. I wasn't there, you were there, you know what happened, I don't know. So that's something that you bring out in trial and, you know, perhaps even before, if you show it to them and it's in fact true, then, you know, they'll kick it. But I'm going to find that there's probable cause to go forward with the case for now. Ms. Rice, any prior DWIs?
No, Your Honor.
License?
Check on the license ready second.
Like I said, I'm finding probable cause. I'm warning you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. You understand? You're not allowed to drive unless you have a valid Texas driver license and liability insurance as well, okay? That is a part of your bond condition as well. If you find that you're driving, you don't have insurance or any other violation, you will go to jail. No more PR bonds. Do you understand?
Yes, sir.
Now, you've got great lawyers. They'll take care of you because you have them. I will waive your appearance. You don't have to waste your time coming to court. But stay in touch with them and they'll tell you if and when you have to come back to court.
Yes, sir.
Judge, I'm sorry, I'm running this license. It's not loading right now. Okay, here it comes. Judge, the license is eligible.
Okay, great. So what we'll do for now is we'll have you go to Victoria Sign and Reset. You'll get with Roxanne for your bond conditions. And after that, you're free to go.
Thank you, Judge.
You speak English, sir? Yes or no?
Yes, sir.
Is there a Joya here? Joya? Sir, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Just one moment, Your Honor. Judge, on April 21st, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a shoplifting call at JCPenney and made contact with the complainant witness, a loss prevention officer. The complainant witness stated the defendant entered the store and selected a hoodie, removed an anti-theft sensor, and put the hoodie on. The defendant then exited the store, passing all points of sale. The defendant was detained by the loss prevention officer, and a pair of shorts and a t-shirt were located under the hoodie that were also not paid for. The total value of the stolen property was $100.
So like on a Gray, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any JCPenney. Do you understand?
Yes, sir.
If I find that you do, I will revoke your bond, put you in jail. If you pick up any new cases, if you're a danger to my city, it's not going to go well for you. How old are you?
18.
I'm going to appoint a lawyer today. What are you doing with yourself?
The judge isn't messing around. Random drug tests. Zero tolerance for violations. Fail. Jail. Drive without insurance. Jail. It's harsh, but there's a reason. DWI deaths are skyrocketing, and this judge has seen too many tragedies. Is this tough, love, or an overreach? Either way, one thing's clear. You won't get second chances in this courtroom.
I'm going to school and I'm working.
Where do you go to school?
MacArthur High School.
Hey, I don't want you using alcohol. I don't want you using any weed. I'm going to test you today. Do you understand? If you do, it's not going to go well for you likewise. You mind reaching out to the man? I'm going to have you take a seat right over there, and I'm going to send you for a test. You were to come back. Do you understand, sir?
Yes, sir.
And then I'll have a lawyer for you, please.
I guess we can talk about, I got appointed to a case a little bit late, but he was already on it. So they reappointed him to this guy in custody, Jerry Birch. I might still be attached. That's what I'm approaching. But
I don't see anyone attacked. But regardless,
The issue, Your Honor, is we want to roll.
he's in jail.
He's in jail,
I'm
yeah.
sure he's on bond.
But we want to roll it to tomorrow because
I
I
think
think
you had issued a warrant because he maybe missed a court or something.
Okay, whatever you want. Sure. If you want to roll it, we can roll it to tomorrow.
That's it. All right, thank you.
Okay. And I have Lorenzo Licona. You had sent him for a drug test earlier, Judge?
Coming up. Is that mom?
That is mom.
Okay.
You want to come to?
No, I mean, I don't think she understands. She speak English? Okay. Guys, what do you test positive for?
It was for something positive for chasing or benzo. Okay, well, we need to.
No, sir. No more. I'm gonna test you like crazy. If I find that you're using, what happens? That's right. Do you speak Spanish? Dime con quién andas, yo te digo quién eres. Don't be hanging around with the wrong people. It's not gonna go well for you. I want you to stay in school full time. I don't want you out, and I'm giving you a curfew, so you're not out in the middle of the night. 10 p.m. Do you understand? And I'm gonna test you weekly, so I know that you're not using. The next time, I'm giving you a 50-day pass on the weed. After 50 days, if you continue to test positive for weed, you test positive for anything else without a valid prescription, it's not gonna go well for you. Do you understand me?
Yes, sir.
You will not fall through the cracks here. Okay, thanks, counsel.
Now, you do work and go to school. He works at Discount Tire. Is that good for you? As far as the curfew 10?
It's all good.
It's good? Okay. Just making sure.
Hicimos un examen de drogas y tenía positivo de marihuana y píldoras. Le dije que no más. Le voy a hacer exámenes cada semana para ver si está usando. La próxima vez se quede conmigo. También le voy a dar un curfew que no se puede ir de la casa de las 10 de la noche. Se tiene que quedar en la casa. Si él sale después de las 10, voy a revocar la fianza. ¿Necesitas algo más?
Gracias por ayudarme.
¿Cómo no? Cualquier cosa que tú necesitas, me avisas y lo hagamos, porque no quiero que él se falle de más. No puede comunicar con la otra persona. Do you know who the co-defendant is in this case?
I do not.
Guys, who's the co-defendant?
Yes, sir.
Like, is it friend, relation,
Oh.
brother?
Not sure.
I don't.
Stipulation.
So I told him no using drugs, no using alcohol. I'm getting him a curfew.
I don't know.
Guys, put a monitor on him, please. And no contact with
I don't believe
the,
there is a co-defendant in this.
no, there is.
There is.
There is.
There is. Just the dude didn't show up today. Si necesitas algo, avisas. Come on.
Yes, sir.
Judge, are you fixing the turkey with the?
Yeah,
Go ahead.
yeah, 10 p.m.
Okay.
10 p.m. So you have a lawyer.
Tienes un abogado aquí.
If you need
Si
anything,
necesitas cualquier cosa,
let the lawyer know.
déjalo saber.
If he starts misbehaving in your house,
Ya sabe que comportarse mal en la casa,
you let me know
le dejas saber al juez
and I will take care of him for you.
y yo me encargo de él.
Okay.
Okay,
Okay?
está bien.
We're going
Thank
to put a
you.
monitor on him so we know
Vamos a
where he
ponerle-
is at all times and we don't want him out in the middle of the night.
Y no nos quedamos afuera
Target as well.
y no puede regresar al Target. Va a tener un toque de queda, ¿entiendes?
Sí.
Okay? Okay?
Okay, gracias.
Thanks. Miss Washington, ma'am, you're charged with possession of marijuana. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On April 21st, 2025, in Harris County, Texas, a law enforcement officer conducted a business check at the convenience store. Law enforcement officers observing surveillance saw two males engaging in hand-to-hand transactions and leaning into the passenger side window of a black sedan. The law enforcement officer made contact with the defendant, the driver of the black sedan, and observed marijuana in plain view in the cup holder vehicle and carried out a probable cause search. The law enforcement officer found a baggie in the cup holder to contain a green leafy substance identified as marijuana. The approximate weight of marijuana was 0.427 ounces.
Two males have a hand-to-hand transaction.
Yes, Your Honor.
They get into the car.
Yes, Your Honor. They're
Officer
speaking.
goes to the car.
Yes, Your Honor.
Where's she?
She's the driver, Your Honor.
She's the driver.
That's correct.
Ms. Washington, we're going to find that there's sufficient probable cause to go forward with the case. Can you run her license, please?
Yes, Your Honor.
Do you have the ability to hire a lawyer, ma'am? Okay, I can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you, what kind of car you drive, what kind of income you have coming in, and then I'll take a look to see whether you qualify.
Eligible, Your Honor.
Okay, you're not allowed to drive unless you also have liability insurance, car insurance. You understand that is also a condition. I'll have Deputy Miranda give you an application. I'll have you get with Victoria for a reset and then just take a seat for me and take a look at the application. Hi, Lori.
Hey, Judge, Mr. Mendoza, I got a plea. Francisco Mendoza.
Morning,
Judge, he
Judge.
wants to show you his ID for where he works.
This is where I work, sir.
Right.
I've been out of
Out of trouble.
I've been snapping my hands.
He just got out of the mental hospital on day before yesterday.
All we want are our streets to be safe. And you need to understand that the type of case that you have now, the burglary of a motor vehicle, one of two things is if you continue, one of two things can happen. Number one, you're asking to get shot dead because people like their cars and they like their guns. And you mess with the wrong person. I can't tell you how many times we read of someone, something like this, they run away and they shoot them in the back. Really. When that happens, it's over. There's no coming back. Number one. Number two, if you continue with this type of case, they can hit you with a felony. And then you're looking at years instead of days. I'm just telling you of the possibilities. That's why you think before you act. Because when you don't, that's when you end up in jail. See what I mean? You work hard, put your heart into it, you can do damn near anything in this life. You know what I mean? So you're charged with burglary of a motor vehicle. You've worked out an agreement. They're offering you 21 days in jail, credit for the 7 days that you've done. You need to understand that this is going to go on your record. It will be there for the rest of your life. Is this what you want to do? From now on, you're facing a minimum of 90 days in jail. You pick up another case. I'm telling you, it's a 90-day minimum from now on. You understand?
Yes, Your Honor.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf,
Sure.
confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, you can never change this. Do you understand? Is this what you want to do? How do you plead to the officer, guilty or not guilty? I'm going to find you guilty. I will follow the agreement, send you to it. Good luck, sir. Keep working, man. I'll roll your court costs. They won't owe anything. All right.
Mr. Rolock, he was sent down because I had reset him, but I did get in touch before he was sent down to his father. Can I bring him back tomorrow and get him?
Of course.
Okay.
Whoa, you got to hold it. Go that way. You're good.
Right here.
You got to hold it, Dad?
Mm-hmm. His
Like,
stepfather. Yeah.
Real dad?
No, his stepfather. It's his baby brother's father.
Okay, is this the dude that he was talking about?
Mm-hmm. And I spoke with him. He said he would help him out. He gave me his address. I have his phone number. So I'll call him back today and tell him.
And he can stay at that, he can stay at that house? Okay. Should we put a monitor on him? What do you think?
I don't think so.
I think tomorrow we can address the condition.
Okay. I definitely want to test him because I want to make sure he's not using, take care, man. Okay, yeah, well, we'll talk tomorrow, Lori.
Okay, thank you, Judge.
So what are we doing?
This is the case that was transferred from court 16. It was put on the docket today. You already knew about it, but it's just that he's here.
We knew that they were going to file it,
Yes,
right?
uh-huh.
I think we already have conditions on him.
Judge, the new case that was transferred from 16, there's not even a bond in the system. So that's why.
I mean, I'm showing there's $100 bond.
Are you looking at, let's see,
The 255-9015.
right, but a bond wasn't posted. It's set.
Okay, so we'll give him another PR bond.
Yeah.
And then all the conditions that we have now, we'll have on him.
Does he need to re-sign those conditions?
Yeah, he'll have to sign.
Okay.
We'll he'll have to sign for the bond too.
Okay.
So just don't let him leave. She's gonna call you up to sign a bunch of stuff and then after that, you guys can get together. Okay.
I have Mr. Anderson on docket, Your Honor.
Ready?
I am ready.
Am I calling you, Mom?
Mr. Anderson, you gave us a short time frame to get back, Your Honor. We made it back.
Okay. Good morning, Mr. Anderson. Come on up. Sir, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail with credit for the 3 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. From now on, you're facing a minimum of 30 days in jail for any new cases that you pick up.
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, there's no turning back.
Yes, sir.
Is this what you want to do?
So,
How do you plead to the offense?
see,
I'm going to find you guilty. I'm going to send you to it. I'll roll your court costs so you won't owe anything. Good luck, to you, sir. Thanks.
Thank you, Your Honor.
Please.
It would be.
Yes, ma'am. All right. Good morning, Mr. Manetta. So you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 1 year in jail to be probate. I'm sorry, 1 year in jail with credit for 241 days that you have already served. You need to understand that this charge will go on your record, and this now makes 2. What happens on the next one? What happens on the next one?
bad things.
Hmm?
Bad things.
Yeah. Prison. You're looking at a minimum of 2 years, a maximum of 10 years in prison if you pick up another DWI. And I'm going to tell you now, you don't have to be stupid, falling down, piss-ass drunk to pick up a felony DWI. When they run your license with the faintest smell of alcohol, they're going to light you up and just, it's not going to go well. So don't get into a car, even if you've had a sip. Do you understand?
Yes, I understand.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this offense, like I said, it's going on your record and it will be there for the rest of your life.
Yes.
Do you understand?
Yes, sir.
Is this what you want to do?
Guilty.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty. Guilty.
I'm going to find you guilty. And is it true or untrue that you had a .15 or above? Okay, true to the enhancement. I'm going to send you to the agreement. I'm going to suspend your license for a year. Do not drive until you get a license, and good luck to you, sir.
Thank you, Judge.
Hi,
Good morning,
tell me
Judge.
something nice.
Michael Rohak. He's charged with 2 BMVs, which they have to rip, but it looks like he was just sleeping in somebody's car.
Oh, he's in jail?
Mm-hmm. It's asking for a PR bond.
Wow, they set the bond at 15,000. So he's on bond for a BMV, picks up another BMV.
Was he on bond? No, he was.
Yeah. He picked up a BMV 423.
And then got out.
It's a GOB, and then 5 days later now picks up a second BMV. Where's he going?
He has no place to go.
I'm not, if he's got a place to go, we can talk. But for
Okay.
me, just to let him out on the street and hope and pray that it doesn't happen, I mean, really?
And then I have Mr. Morris Stone.
Okay.
On the jail docket. He's charged with 2 criminal trespass, and they have done a mental health PTI. I want to do a mental health PTI on him, so I would need a PR bond. Okay.
Whatever you need.
All right. Thank you, Judge.
How did it turn to this? How did it turn into this?
Except we have to ask the guy with the car, because it wasn't an issue at all.
No. I mean, why on the street? Why on the street? There's nowhere else you can go?
I just don't have a place where I can go right now, that's all.
Do you have any family anywhere?
North side, there's no shelters, and then
No.
family,
Do you have family?
there's one family member that I can contact. I just haven't had a chance to.
Who?
Mr. Jesse James Valdez.
No. Is uncle, aunt, mom, dad, brother, sister, anyone? Who do you have in your life?
Mr. Jesse James Valdez, that's the only person that knows me from the time that I was
Where's mom
young
and dad?
to now.
Where are mom and dad?
My mom and dad both passed away.
Okay. Do you have any brothers and sisters?
I have one little brother, but I don't really speak to him that often.
Why not?
I just haven't had a chance. I mean, I don't even have a telephonic or a phone, so I don't really just communicate.
If we
with
give
people
you
like
the ability to call, do you know the number?
that. Yes, sir.
I'd like you to try to call your brother. I want you have no one in this life that is going to bond you out. We gave you a free bond, asked you, hey man, be good. Don't pick up any new cases. You done picked up another BMV 5 days later. I'm not going to continue with the same thing. If you want to get out, the only way is if I know that you have stable and someone in your life that is going to look after you. And I'm not talking a girlfriend or just a passerby. No, I want someone real, like baby brother. And if you do, then we can talk about letting you out, but you go to that person. No dope, no alcohol, but I'm not letting you out just to go on the streets. This is what's happened. Do you understand? We've given you a great lawyer. Let her know. You can try to reach out to baby brother to see if he'll take you in, or anyone else.
It's not my brother, it's Mr. Valdez. His dad, that would be the person that would be able to take care of me and everything like that.
Okay, we'll call. When I go back there, I'll get the number and call.
Okay? All right. Good luck, Mr. Rohan.
Thank you.
On your docket, 3, to be exact. 1 is out on bond and 2 are in custody. Which one do you like to?
Dealer's choice.
Sounds good. I'll take on, I guess, the bond one first. It's Mr. Macero Barcenas, Judge.
Barcenas.
He's the one who was offered the decision-making class. I told you yesterday that I believe that he had to class and I was gonna help him take it.
Oh, yeah. Okay, did you get it?
So I just spoke to him, telling he hasn't started yet. He didn't know how to access it, so now he's in the process of actually taking it. So I have helped him get into the class to actually.
Is he here?
He is here, Judge. He's sitting in the back.
He's had since March. The class was offered March 4th. We're now 4/29. We've literally given him more time, at least 2 times.
I know, Judge.
And he still hasn't done anything?
I think maybe it was a miscommunication on what.
No. I'm gonna roll him day for day until he gets it done. I mean,
Yes,
it's
sir.
not fair.
Yeah, I
Really. So if he doesn't get it done, then he's just gonna have to, tell him to get it done today.
Yes, Judge.
And
Absolutely.
roll him to tomorrow. And if he
Yes, sir.
doesn't get it done, then I'm gonna roll him to the next day. And then at some point he'll get it done. Then he'll know that we're in business.
Sounds good. Thank you, Judge.
Unacceptable.
Um,
Okay, who's next?
the next one, Judge, is Mr. Noel Dominic.
And you, if you're not here tomorrow, you don't have to come. That's why we have it so that's, okay?
I'm here.
Okay, all right. Because I don't want you to have to take extra time.
Yes, sir.
Them,
Thank you.
yeah, okay,
The next one's in custody, Mr. Dominic, Judge. Noel Dominic.
okay.
This is, my case. I actually wanted to put a PC in this case, Judge.
Last name is Noel?
Dominic, Dominic. I believe he is. I thought I saw him.
Why do I not see it?
I'm sorry, Rena. I'm sorry. I don't know why I put Dominic. It's Rena. Rena.
Okay, there we go, Rain. Okay. You ready?
Yes, Your Honor.
This is a new case, right?
Yes, Judge, from last.
So it's DC.
All right, Judge. On April 19th, 2025, in Harris County, Texas, an officer conducted a business check of an Exxon gas station. The officer observed a motor vehicle at the gas pump without a front license plate and with the brake lights on. The officer observed a male asleep behind the wheel in the driver's seat. The officer contacted the defendant and observed him to have red glossy eyes and a strong odor of alcoholic beverage emitting from his breath and from his person. The defendant initially refused to obey verbal commands texted
I
the
remember
vehicle.
this. We did do this. And
We
they
did.
saw him
On the
through
cameras.
surveillance driving into the thing.
Oh, I see. I guess I didn't see in the DMs and
That's what, I remember this because I had the same issue with you until they told me that they have video surveillance of him pulling into the station.
When does the surveillance video say that? I guess how much time before he got there? Because I saw the police.
That, we didn't get into like how, and
Gotcha.
all I know is that they've got video of him going in and that's why.
And the reason why I was asking, Judge, because I found a case that's actually strikingly similar. It's from Austin, but it is strikingly similar where they found the toilet profile, no probable cause. And if you like, I can leave
They
it.
have him on video pulling in?
Well, no, Judge, but it does talk about how it's, I mean,
I'm with you
Yeah.
until that point.
okay. Because even if they have operation, I don't know how to get intoxication. That's the issue. There's nothing, no signs about intoxication other than a sign of introduction of alcohol into his body, but nothing about
They
intoxication.
pull him out and he's got all the signs though, right? If I remember?
Strong odor of alcoholic beverage
Yeah.
coming from his breath and from his person, appear to be disoriented, red glossy eyes.
And he's asleep.
Right. But red eyes, what could be many things. And then, I mean, these are factual issues. I get that. But from what I
This is
saw,
probable cause.
right.
And you've got a guy that's pulling in, he's asleep at the pump, cops go try to figure out, hey, what's going on? Displays all the factors. And then, yeah, I think that there's enough for peace.
Okay, fair enough.
Sure.
Okay, so then I got one more judge in custody.
So
So peace.
hold on. So
Yes, Judge.
he's at no bond because of the ag assault upstairs. He's set tomorrow. Guys, on him, no, this is on Reyna, page 35. No drugs, no alcohol, random testing. Can you see if he has a license?
Yes, sir.
Listing? Just all the standard conditions.
Judge,
Do you want,
we have conditions in place for RUA.
we do? We have it already? Okay, all right, I think we're good. Do you want to set it for later this week to see what happens? Or do you want to do it far off? It's up to you.
No, let's see what happens, Richard. It's okay. I just want to do maybe a quick reset. Yes,
Yeah.
that's okay.
Okay, who's your last one?
Last one is Rivas, Judge. He's also in custody. And this is the one I approached PC late, yesterday because I was plenty late. We're
Okay.
talking about that there was nothing in the DIMS about knowledge, that actual knowledge of falsity.
You have anything?
So what I found is, nothing specific. There's been no case law specifically addressing that issue. But from what I found is that there is case law regarding the element of knowledge where it has to be actual knowledge. Mere possession of an item is not enough to provide any type of actual knowledge, at least as prescribed under the statute. The statute controls, the language of the statute controls and explains.
Ladies, can you take a look?
Yes, sir.
And then I can just take a look and pop with them real quick and then I guess, let me thin the line and then we can explore it further. Okay, can you give me just a couple seconds? Let me thin them out because it's gonna take a little bit longer. Hey, sorry, I'll let you go around. You can reset John so you didn't have to wait.
Yeah, but, I reset and then he said that you wanted to.
Yeah, I'll admonish. Okay.
Hey, Judge.
Sorry to keep you waiting.
No, it's just, so I'm just reapproaching again on Rebus, the ID case.
Oh, okay.
So I spoke to the state, and so it seems like we're at disagreements on this. And the argument that I have, Judge, I think I have something that is pretty compelling. There's a case law that I have called Fledging v. State, and that's not regarding an ID, it's regarding a check. But the court looks at the element of knowledge in it, and it talks about how possession of that forgery check is not enough to meet knowledge because mere possession alone is not enough. It's similarly here, by analogy, a possession of this ID is not enough because it would create an absurd result. The purpose of reading the statutes is that the court must interpret it by its ordinary language. And the language says that it has to have knowledge, actual knowledge of its falsity. Now, if for some reason it's ambiguous, then it must be interpreted in a way that doesn't produce an absurd result. So if we interpret it to mean the way the state is interpreting that mere possession is enough, then it would basically allow the police to arrest anyone that has an ID that has any type of dimple or any ripple or any type of defect in production, because that's what's happened here. The police officer's only basis for arrest was that the texture of the ID was wrong or different than what he's.
That's why they do licenses in special ways so that officers know that they're fake or that they're real or fake, right? They have little so they can sit there and they can do this. It's got special colors, special diagrams on it to be able to ascertain whether it's fake or not. And in this case here, there's a piece of tape and the paper's kind of like coming off.
That's not what I actually read in the DIMS. So the police officer in the DIMS only says that the texture was off. That was not what he was used to. But my point is kind of emphasis on that point that even if it is produced in such a special way, production can still be defective for whatever reason. And that shouldn't subject you to deprivation of liberty.
But at that point, that gives the person the right to investigate more. When something is amiss, right, that's the reasonable suspicion, right? The thing that gives them the authority to investigate further to see, hey, is this legitimate? Because if it was legitimate, then they send them on their way.
Agreed. But it gives the police right to investigate further for that offense, but not reasonable suspicion to arrest. And that's the thing that the state would need to find that the reasonable suspicion for every element of the offense, and it's the state's burden to produce that. And they haven't produced anything to show that there was reasonable suspicion for the actual knowledge of falsity.
State.
So, Your Honor, a couple things. One, this was something that the officer again felt. It's not real. It easily became unglued. The officer is going to be able to testify that, well, this was not something that came to the Texas Department of Motor Vehicles. In fact, the defendant even said, yeah, I don't have a license. Mine's suspended. Lack of knowledge of the law is not a defense.
Right. Ignorance is never a defense, right?
And I would argue, Your Honor, we're not saying this is just mere possession. We're not arguing that. We're saying if you take a look at all the facts and circumstances surrounding this case, there is overwhelming evidence that there was intent by the defendant to use that driver's license because he gave it over to the officers when they responded to the accident. They easily could tell it was fake. It even unglued on scene. So there's enough.
Unglued on scene.
The thing is that I don't see that anywhere in the DIMS of being unglued. And the fact is that
this did not have the same texture, was not laminated, or it was laminated, but was not issued by the state. Card easily became unglued while holding it and was clearly made from paper and laminate.
I think that there's enough to go forward.
Okay. All right. Sounds good. All right. Thank you.
For sure.
Judge, I'm here on Mr. Jerome Hunter. He has that BVR that you put on today's docket, so we can address.
Come up, Mr. Hunter.
Judge, his mom is also here. Would it be all right to have her come up as well? Judge, if I may? I explained to Jerome and his mom that the reason why he's here is because there was a reading from this, that he was past his 9 o'clock curfew on the 15th. I talked to him about it. He's a young man that actually has a pretty good future, Judge. He's got a football chance in college. Both he and his mom knows the severity of, your words in terms of him being home at 9.
She would be ashamed to ruin a potential football career because of criminality, wouldn't it?
So anyways, Judge, on that particular night, what had happened was it was still during football. I think football was over with now. So he made the mistake. He went out to go work out with football with, is it your cousin?
My cousin.
Your cousin. And that's where he was that night, Judge. I asked him if he could get something from the cousin. He's got some text messages going back and forth of them meeting at a park by the house, at a park to work out. And that's that. And I think that's the only violation he's had, Judge. I think both his mom and Jerome realized that, hey, cannot happen again. His mom tells me that she would definitely, he's never been in trouble,
Let's do this. I'm going to send you for a drug test, Mr. Hunter. Okay? Send him for a drug test. You're to come back and then we'll go from there.
Yes, sir.
Okay?
Yes, sir.
All right. Just take a seat for me. We're going to send you right now.
Back there or in
It's fine.
Judge, he is set originally on the 7th, so if everything comes back okay, we'll just take it. Okay.
It's a Mr. Serrano, Judge.
Serrano, with a C or with an S?
Yes.
So he has an evading out of court 6, and then he's got our case.
So this one is pretty straightforward. It's one where it's where Pennsylvania requested an extension, but it was for the entire 30 days. And because of the nature of it, another court would grant it. And so they've already stated to me that they wouldn't be able to pick up in time, and so I'm going to dismiss it. However, they requested that the court admonish him before I dismiss the case, stating that the warrants are still active and that, and
Yeah,
it's also,
totally.
but he has 24 counts of failure to appear for retail theft. I mean, it is, and obviously the evading is an aggravating factor, but just admonish him.
Pennsylvania can't come here? I mean,
Not in time. That's what I mean. It's typically the court grants 3 days, but they need the full month. And so because it's not an aggravated offense, is you've never granted.
is it just like a retail, like
It's a
a,
failure to appear, but it's so many retail thefts, just the aggregate amount that it becomes a felony, but they're,
sure.
but it was issued out in 2024, 2023.
Are they going to refile the hold?
No, the hold is still, well, the hold is going to be released because we can only hold.
I mean, okay, so
But the
you're going
warrant
to
is still-
dismiss, are they going to,
Fugitive case because they're unable to pick up in the allotted time, but the warrant is still going to stay active. And so he could get arrested again. He can get arrested in Montgomery County or Liberty County or Galveston, anywhere. It's still active. So, I mean, he could get picked up in 3 days.
so I guess we'll just, at some point,
He made bond on the evading, so he's able to go back
Yeah.
today. I mean, and-
surprised that they did with the fugitive case, that they gave it to GOB? What? Yeah, they gave it to GOB.
They did.
Yeah, I believe he has court tomorrow.
He, I think.
Serrano.
No, in 2 days.
Yo te voy a traducir para el juez.
Good morning, sir.
Buenos días, caballero. Buenos días. Buenos días.
You are wanted out of the state of Pennsylvania
Tiene una orden de arresto del estado de Pennsylvania.
for 24 counts of retail theft.
24 acusaciones de hurto de una tienda.
The state of Pennsylvania
Estado de Pennsylvania.
doesn't have the resources to come get you within the allotted time.
Y a venir a buscarte en el tiempo que le toca.
So they're going to end up dismissing or withdrawing the hold.
Van a quitar la orden de detención que
The
tienes.
thing that I want you to understand,
Yo lo quiero que entiendas usted.
that hold
Esa orden de
and that
detención,
Pennsylvania warrant
esa orden de arresto que
will
tiene
always remain active
todavía y va a quedarse siempre activo.
until you go take care of it.
Que usted vaya ahí y
You
termina
could
de ser
literally
encargado.
walk out of here and they can rearrest you.
Literalmente puedes salir de estas puertas y te pueden agarrar y
And every
arrestarte.
time you will sit there for who knows how long.
Y te arrestan y cada vez que pasa eso te vas a quedar ahí atrás y a saber cuánto
So
tiempo.
you take care.
Hasta que usted toma y se ponga en carga de
Yo le
esa
estaba
cosa.
diciendo a la abogada eso mismo, que yo voy a viajar para allá.
I was telling the attorney that very same thing, that I'm going to go travel over there.
I don't care what. It doesn't matter to me.
No me importa ni sé.
I'm telling you,
Yo solo te estoy
so you
diciendo
take care of it.
que hasta que usted
And the thing
termine
is,
ahí con eso,
when you get arrested,
arrestar, si no,
never at a good time.
nunca va a ser un tiempo apropiado
It'd be
que
at
puedes.
the worst possible time in your life.
Tiempo más peor que puede ser.
So it would probably be a good idea
Pues probablemente sería una buena idea
to take care of it as soon as
para
possible.
arreglar todo este asunto lo más pronto posible.
Yes, sir.
Yes, sir.
You still have the open case in court 6.
Todavía tienes un caso abierto en la corte
Don't have to
número
worry about
6
that.
y todavía tienes que preocuparte sobre eso.
Anything else?
¿Algo más?
No, Your Honor.
Okay.
Nada más.
Good luck to you.
Buena suerte.
Thank you, Honor.
caballero.
Excuse me.
Okay. Good morning, Ms. Zaragoza.
Morning.
And you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 54 days in jail with credit for the 18 days that you have done. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported,
Sorry?
excluded from the country, denied naturalization under federal law. What's the problem?
I'm a US citizen.
Okay, I still have to explain you that if you're not,
Explain the consequences of it. That's okay.
Okay.
these are all the rights that you're giving up. You're saying that I'm guilty, I don't want to go to trial. you give up the right to appeal. So once you accept this agreement and once you plead guilty, you can't come back at a later date and try to change it because you don't like it anymore. Once you plead guilty, it stays like this forever.
Yeah,
Is this what you want to do, man?
yes, yeah.
Y'all think of us all guilty or not guilty?
Guilty.
Must also inform you that from now on, you're facing a minimum of 90 days in jail. You understand?
Yes,
All right, good luck to you, man.
thank you.